Good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court this morning. Today, I will let you know if I found probable cause, and then we will talk about release conditions. I want to remind you that today is not your trial date, it's not your hearing date. This is not an adversarial hearing, so if you wish to talk about your case, I would advise you not to, because everything in this courtroom is being recorded. If you wish to say something to the court, I'd encourage you to speak with your attorney, either if you have an attorney from the Public Defender's Office or if you have private counsel. If you do have private counsel, they will come to the courtroom and will be able to speak on your behalf. If your attorney's not here, you can also let us know, and we will see how we can accommodate you through that process. I will call each person's name, and you'll come up to the microphone, and then we will address each person individually. And has the jail asked for anyone to be called out of turn this morning?
Yes, Your Honor, there are three people.
Okay,
The first one is on page 22, Mr. Poindexter,
okay.
and the other two gentlemen are on page 28, Mr. Hamilton and Mr. Whitaker.
Mr. Poindexter is here, present judge at the podium at Maine, and it's municipal.
Your bond is $2,500 and you're afforded. Yeah. If we have $2,500 in your property to buy
Did you say Poindexter for the
we have
first one?
$2,500
Thank you. And then you're the sign language interpreter? Okay,
Our sign language interpreter is here. That case is on the last page of the docket. He is in North Broward. His name is Michael Evans, and they went to get him. As soon as they have him, they'll let me know, and
okay.
we can
All right, thank
we can
you.
help you out, since you're helping us out.
All right, thank you. So we'll start with Byron Poindexter. Mr. Poindexter, you're before the court for a misdemeanor capias this morning. The capias is because you did not show up for arraignment on June 3rd, and it's a possession of paraphernalia. It's a municipal ordinance violation charge. So, Mr. Poindexter, what do you wish to do today, sir?
I want to resolve it.
All right, all right.
Would like to resolve it, ma'am.
Okay, Mr. Poindexter, if you wish to resolve your case, it'll be adjudication and time served. Do you wish to accept that, sir?
Yes, ma'am. Yes, Your Honor.
All right, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth?
Swear to tell the truth.
Okay, you can put your hand down. And Mr. Poindexter, do you understand everything that's going on here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need time to speak with an attorney?
No, ma'am.
Have you ever been treated for mental or emotional illness?
Just from the time I went to the hospital, that was it.
Is that a yes or a no?
Yes.
Okay, is there anything about that illness today that will prevent you from making an intelligent decision about taking this plea?
No, ma'am.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, sir, what plea do you wish to enter, guilty or no contest?
Guilty.
All right, I accept your guilty plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Do you have an attorney?
Junior Whitaker,
He's here, present judge at Maine. He's approaching.
all right, Mr. Whitaker, you're before the court. Charge number 1 is driving, no proof of insurance on 1, and then on 2, it's a felony capias for with a no bond hold, and it's not for magistrate. The charge is a grand theft charge, looks like before Judge Siegel. So you have court tomorrow before Judge Siegel at 8:30. And as I said, 2 is a no bond hold. Your bond on count 1 is $100. Good luck, sir. Shane Hamilton.
He's here present, Judge,
All
Mr.
right,
Hamilton.
Mr. Hamilton is before the court. Charge number 1 is a misdemeanor capias. And then on 2, it's a violation of community control on a felony charge. It's has a no bond hold. So Mr. Hamilton does have court tomorrow and also on Thursday for both the felony and the misdemeanor cases, okay?
Okay. Good luck, sir.
And then as soon as we have Michael Evans, you let me know.
Yes, Judge, they're bringing him right now. They're gonna call me as soon as he arrives.
Okay, so then we can go back to the top. Jennifer Brown.
North Broward, Judge.
Okay. Good morning, Mr. Shade. Ms. Brown, you're
ma'am.
before the court on a misdemeanor capias for a trespassing charge. The city is extending an offer of adjudication and time served to resolve the case. Do you wish to accept that?
Yes, ma'am.
All right, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Ms. Brown, do you understand everything that's going on here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with the attorney?
No.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Then what plea do you wish to enter, Ms. Brown?
Guilty.
Okay, I'll accept your guilty plea and your sentence is adjudication and time served. Good luck.
Thank you so much. Have a wonderful day.
You too. Patricia Helhosky.
She's approaching, Judge. She's here at Maine.
This is also a municipal ordinance matter. Ms. Helhosky, this is you're before the court for a misdemeanor capias on an alcoholic beverage violation. What do you wish to do, ma'am?
I want to resolve it.
Okay. All right. All right, if you wish to resolve the case, will be a withhold adjudication and court costs. Do you wish to accept that?
Yes.
All right, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes, I do.
Okay, you can put your hand down. And ma'am, do you understand everything that's going on here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with the attorney?
No, I don't.
And have you ever been treated for mental or emotional illness?
No.
And do you understand that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, ma'am? Guilty
Yes.
or no contest?
Guilty. Guilty.
Okay, accept your guilty plea and your sentences withhold adjudication and court costs. Good luck.
Judge, I have one other matter if you'd like to resolve it. It's on page 22. Last name is Poindexter.
We did him. We handled him. Yes. All right.
Thank you.
We have Mr. Evans, Judge.
Okay, we have Mr. Evans. All right. Good luck, ma'am.
Okay.
Yes. And
Thank you.
he's at North Broward?
Yes, Judge.
Okay.
It's the second to last case on your docket.
Come on over. Good morning. Please her affirm to translate from sign language to English, English to sign language. Thank you. All right. I know. We'll see. Is he good?
Yeah, he's like,
Okay.
get down a little.
Oh, boy.
You're too high up, you're on.
Well, you can't see her hands.
Oh,
Yeah, she needs to be up a little more.
really?
Or if you could step to your right a little bit. Okay. Is that better? All right.
I can only see her head.
Yeah, you can only see her head.
How about if you come up on the podium? And-
I think we've established that's the sweet
You
spot.
get a phone book, I think.
We need a step stool or something.
You are Creole too. We'll call you next, okay, thanks.
Nope. Oh, on the other side?
Have to put an X down.
I know.
Perfect.
You want a chair? Did we take away the chairs? Oh, we took the chairs away. We had some chairs up here this morning.
Me?
Yeah.
Thanks, Ed.
Can we borrow one of the chairs again?
Yes, yes. Yeah, what, this one here?
No, the one on wheels or? No wheels. Oh, no wheels. Oh, wait.
I know.
People kill me with this one. It's misplaced. Apparently so.
You're welcome, thank you.
You see me okay? Yes, perfect. Nice
All
and
right,
clear.
now we've got it. All right, Mr. Evans, you are before the court today for one count of possession of cocaine. All right, I see a note here from yesterday, that he has private counsel. Someone has that written on the note from yesterday. Is that correct?
I don't know anything about that, Your Honor.
Okay,
I didn't even speak to a lawyer.
okay, all right. I'm just going by the notes that I saw. All right, so you have one count of possession of cocaine, sir. And I find probable cause. And the standard bond is $1,000. Are you able to post that bond?
I can, but I needed to I don't have access to a phone to get anybody to be able to come and get me. So I've been trying to make a phone call. It's $100 for the jail bond, but again, the TTY equipment that's here, I'm stuck. I can't, nobody's been able to give me a phone to be able to communicate with anyone.
If he has a number, I'll be glad to make a call for him. Who did?
I was trying to call my mom, but I know my mom had mentioned that she can't, but I don't know if she's even available, to be honest, for this jail bond. And I know that, and this Friday, I was supposed to be going to rehab and checking in drug rehab this Friday.
Okay. Do you want the attorney that is in the courtroom with me from the public defender's office to make a call to your mother? You can give us the phone number.
Yes, please, if you would be willing.
What's the phone number?
It is 954-725-7587. Her name is Donna.
All right, and then before we make that phone call, Mr. Linder, does the state have anything that they wish to say?
I would just want the court to be aware that Mr. Evans pled out to a misdemeanor domestic violence battery before Judge McHugh 3 days prior to this arrest.
Okay. All right. So
Yes.
if you'll give us a few minutes, we'll make the phone call to your mother and then we'll make a decision. Does he have any other priors? I'm sorry.
That's okay, that's all I saw, Judge.
All right.
I left a message for her, Judge.
Okay.
If he doesn't have
Okay.
that bad a record, if the court wants to inquire as to what his living situation is, if he lives with his mom or has a place to stay.
I live with my parents currently.
And there was note that he pled out a misdemeanor case. Was that to probation or just time served? Or
It was
what?
just a withhold court cost.
All right.
Maybe the court would consider some form of ROR.
All right. At this time, I will ROR him, and we'll just do a straight ROR. Sir, you need to pay attention to the mail so that you know when you have to come back to court on this case. Do you understand that?
Yes, yes, Your Honor.
All right, good luck.
Right, and I will call your mother after court to let her know what happened.
Okay. All right.
Okay, good luck.
Thank you, Counselor. Oh, but I don't understand, what does that mean? A letter, does it mean, ROR? Can you explain a little bit more, Your
The
Honor?
letters stand for release on your own recognizance. So you don't have to post a bond, but you must pay attention to your mail so that you know when you have to come back to court.
So you're out of jail.
Okay, thank you.
All right, good luck.
Thank you, Judge.
Ms. Hannah, thank you very much. It's always exciting when you come. All right, Siltane DeBruce.
Yes, Judge, our Creole interpreter is also.
Okay,
Thanks so much.
This is North Broward, John.
okay.
Yeah.
She requires the Creole interpreter.
She's here, thank you.
I
Good
got it.
morning. Do you,
Morning.
to translate from Creole to English and English to Creole?
I'm English, I'm Creole. I talk Creole.
All right, Mr. Bruce,
Yeah.
you are before the court today
Ou la devan tribunal la jeudi an,
on a misdemeanor KPS.
pou yon mauvaise conduite, ke yon mandat ou te mette pou mauvaise conduite,
For trespassing.
paske ou te entre yon kote ilegal.
You're trespassing, they va pour marquer trespassing.
The court
It's
finds,
for- it's for me.
probable cause
Tribunal la jwen a se cause probable,
and,
It's for me. It's place for me.
what, she's saying what now? Ask her what she's saying.
ki sorti?
Reza se pamni mdwe show, mdwe kon MPAIS la dan MP soda mbre. Se pamni.
It's my place.
What?
Okay,
Your Honor, if I may,
yes.
Ms. DeBruce wasn't even supposed to come back today.
Li pat dwe pou retourne la jodi an.
This case is before Judge Lerner Wren.
Ka sa se de pou juj Lerner Wren liye.
So I think all parties agreed just to have the court find PC yesterday.
Mwen tout patisipan yo te aksepte pou jwen koz probab yer.
So hopefully she would just get brought before Judge Lerner for something more productive than.
Pou yo ka menen devan juj Lenoren pou yon baye ki pi afektif.
Okay.
I believe that to be correct.
Mwen gen an keksyon pou.
All right,
I
so
have a question.
An keksyon an. Mwen ka bon keksyon an.
Can I ask a question?
Sure.
Okay, the police take my paper from 1993. I need my paper.
Okay, you will.
ID, social security, everything.
Okay,
My
Mr.
birthday
Bruce,
certificate.
you will go before your division judge tomorrow, just say tomorrow.
Wap wale demen devan juj apropye yo.
And you'll be able to discuss those issues,
Wap
okay?
ka pale avek juj sa de sak pase.
All right, good luck.
Okay.
It looks like the confusion was, I see that yesterday Judge Barner signed it, but then it says for bond purposes only. That's written on there, so I guess that's why they brought it.
Oh.
I don't know. That's weird. All right, Shandon Josh.
She's here, President Judge at Maine.
All right, Ms. Josh, you're before the court for one charge of neglect child without great bodily harm, and the court finds probable cause. I'll hear from the parties.
Your Honor, the state would be requesting a $5,000 bond, no victim contact. The child's initials are CM.
Okay,
I see no history. This is based on the specific allegations.
okay.
Judge, as far as the monetary bond, at this time in speaking with Ms. Josh, she will be able to have someone post that monetary bond, so nothing in reference to that. As far as in reference to the special condition which the state is asking for, as far as the no contact, my understanding is, I believe, and the state could correct me if I'm wrong because I don't have the PC affidavit, I believe the date of incident was earlier this year. In speaking with Ms. Josh, it was a misunderstanding. She's looking forward to speaking to she filled out paperwork for the public defender's office with their attorney to let her know exactly what was said to the officers when this was brought to her attention earlier in February. But Judge, at this time, we're asking the court not to impose that no contact order.
Is there someone else that lives in the home with Ms. Josh and the children?
Right now, the children are currently with her uncle, aunt, and grandmother.
Okay. All right, so I'll impose a $5,000. Well, when you say that the children are with them, do you also reside in that home, or do they reside separate and apart?
Separate and apart, Judge.
Okay, all right, so I'll impose a $5,000 bond at this time, okay?
Your Honor?
Yes.
We would ask, though, especially considering it's not as though she has custody of the children. The child is now a witness in a criminal matter, so we would
Okay.
ask that the no contact, and certainly if there's a reason why that should be, well, I'm getting a confused look, but didn't they just say the children are with other family members?
Right now, the children are with the family because she's here in custody.
Oh, well,
That is why. But the kids normally are with her.
I don't want to speak for the court, but I
No,
thought the court was
okay,
asking.
that was, my
Oh, then I got
question was.
confused. I apologize,
No,
Judge.
right, my question was, is she living with the children? So I am going to.
She's living with the children since February, Judge.
All right, so then.
I mean, since
All right,
forever.
no victim contact until further order of the court then. I'll impose that, okay? The children are all witnesses, so I think it'll be safer that we do that at this time. All right, Pamela Goodwin,
No problem, Your Honor.
all right, Ms. Goodwin is before the court on a battery on an officer. 2 is resisting officer without violence. 3 is disorderly conduct. 4 is trespassing. 5, 6, and 7 are violation of pretrial on misdemeanor cases. Those are all no bond holds and not for magistrate. The court finds probable cause. And does anyone wish to be heard as to the other counts?
Your Honor, based on the nature of the pending charges that she has no bond holds on, I'd be and the allegations in this case, I'd be requesting a $2,000 bond on count 1.
Okay.
In light of the no bond holds on counts 5, 6, and 7, we would not object to that. I spoke with Ms. Goodwin, and we're going to make sure that her medical issues get taken care of, right, Pamela?
All right, so we'll impose a $2,000 bond on count 1, okay? Chandrika Brinson.
This is a medical research, Your Honor.
Ms. Brinson is a reset.
Your Honor, the only thing I'd ask is if the court, this has been reset, I guess, since last Friday. If the
Okay.
court could make a probable cause determination, I have no objection to her staying on the docket for bond purposes.
Okay. All right.
Nothing that I've got. You could
The
check with
court
her.
finds probable cause as to the grand theft charge.
Who is it?
Okay? And to be brought back for bond purposes. Tiffany Hackett,
She's downtown, Judge.
she's in court. All right, and it looks like she also has a VOP hearing tomorrow. All right. Thomas Nagel. Hackett's a reset. But it looks like she has a hearing tomorrow too in her division, so. Okay, thanks.
Mr. Nagel is here present, Judge at
All
Main.
right, Mr. Nagel, you're here because you have one out-of-state felony hold. It's out of the state of Texas, and it's a no bond hold, so you should be going before the extradition judge this week, or either as early as Thursday this week or maybe next Tuesday, because they only have courts for extradition court on Tuesday and Thursday. Okay? All right. And then Andre Murray.
Mr. Murray is here present, Judge at Main. He is approaching. Come on up, Mr. Murray.
Hold on, did you take something out? Okay, okay. All right, Mr. Murray is before the court this morning. Counts 1, 2, 3, and 4 are aggravated assault with a deadly weapon. It's domestic. Counts 5, 6, and 7 are touch or strike battery, domestic. Counts 8 through 171 is possession of weapon or ammo by a convicted felon. And then count 172 is a violation of probation with a no bond hold. Okay, and the court finds probable cause.
Your Honor, the state is going to be requesting bond and release conditions in the following amounts. On counts 1 through 4, $25,000 each. 5 through 7, $5,000 each. Your Honor, as far as the weapon offenses, I'm only going to be requesting bonds on counts 8 and 9. One for the AR-15, the other for the over 160 rounds of ammunition. I have no objection to RORs on counts 10 through
On 71.
171. I'm going to be asking for a $25,000 bond on counts 8 and 9. Noting I have great concern for the safety of the alleged victims in this case. Starting with the violence committed against these victims. When his son felt the need to intervene to try to protect the other two victims, Mr. Murray committed a battery against him. The victims felt it necessary to flee to a room and lock a door for protection for Mr. Murray, at which point he threatened to kill all of them by shooting them. When he was stopped by law enforcement, he was found to unlawfully possess an AR-15 semi-automatic rifle in his trunk with over 160 rounds. I would also note, obviously, the court's aware he's on probation. Additionally, in 1995, Mr. Murray was convicted of aggravated stalking and 2 counts of aggravated assault with a deadly weapon and was sentenced to 38 months in Florida State Prison. In addition to these bonds, I would be requesting, obviously, an order of no victim contact, pretrial release with a GPS monitor, no possession of any firearms, weapons, or ammunition, Judge. Nothing further.
Okay.
Judge, I do understand Mr. Murray is being held no bond in a violation of probation, so he's going to have to appear in front of his division judge for some sort of relief. However, in saying that, he's been here his whole entire life. He is working. He works for a company called Val Transport. He's been working for them for about 7 years now. He's salaried. He gets approximately $750 biweekly. So, Judge, I'm asking you to take that into consideration in determining reasonable release conditions for Mr. Murray, and we're also asking for a photo order as well.
All right, I will sign the photo order. It is always concerning when someone is standing before the court on serious charges, and when the state is talking about the priors, that the person has a smile on their face. I never understand that, so. These are serious allegations, and at this time, counts 1 through 4, I am going to impose a $25,000 bond. Counts 5 through 7, 5,000. 8 and 9, 25,000. Then 10 through 171, those will be ROR'd, and on 172, Mr. Murray does have a no bond hold. And he does have court tomorrow before his division judge at 8:30.
Your Honor, as far as the
And,
other release,
no victim contact, and no possession of firearms or weapons if he posts his bond. All right. Eric Apedo.
He's approaching, Judge. Yes, sir.
All right, Mr. Peters, before the court, touch or strike battery, domestic, counts 2 and 3 are abuse of child without great bodily harm. The court does find probable cause. I'll hear from the parties.
one moment, Your Honor. Mr. Apato's criminal history includes he had a Dade County theft in '09, possession of cocaine '08, possession of cocaine '07, an arrest for burglary with assault or battery in '06, that was dropped, possession of cocaine '06, improper exhibition of a firearm or weapon. He pled that out. There was also a charge of aggravated assault that was with a deadly weapon that was dropped. That was in '98. Looks like just a drug prior before that. Your Honor, I'd be requesting a $2,500 bond on 1, $5,000 bond on count 2 and 3 for the child abuse counts, and an order of no victim contact.
Okay.
Judge, at this time, no objection as far as the special conditions which the state has suggested. However, the $12,500 bond is something Mr. Rapido is going to have trouble with for 2 reasons. One, the financial reason as far as coming up with that monetary amount, and 2, trying to contact anyone to help post his monetary bond. My understanding is when he was arrested, unfortunately, he was arrested basically with the boxers he was wearing. The officers didn't give him an opportunity to get his wallet or his phone. So he has no phone numbers memorized. He has no way of contacting his brother to help post his monetary bond. Now, he's 42 years old, been living in our community his whole entire life. He's been working with the same company now for 2.5 years called Kaufman Land Construction, where he lives with the alleged victims. They rent, they do not own, and his monthly rent is $1,300 per month. Now, from what he advised me, he really has no sort of assets or property. He would be, like I said, depending on his brother, to post his bond, and his brother's employed at a sanitation department. So if the court were inclined to set somewhere around the neighborhood of $1,000 bond on count 1, $2,500 bond on counts 2 and 3, that may be something that his brother can't afford. But like I said, the problem with that is he can't get in touch with his brother. So I'm asking the court, because of that situation, for level 2 pretrial for Mr. Alpedo, because he can't get in touch with anyone. And also, Judge, I'm going to ask for the court to sign an order to allow him to go back one time with law enforcement to retrieve his property from those premises.
And Your Honor, I just wanted, and I'm just noting for the record, I know the court's aware, I imagine Mr. Romero hasn't seen the probable cause affidavit. There's an explanation for why Mr. Rapido was arrested in the attire he was in and why they didn't bring him back to the home to let him get his wallet and change and whatnot.
All right, so at this time, I am going to impose a $1,500 bond on count 1 and $2,500 on counts 2 and 3, and that's also going to include a level 2 GPS. And I will sign the order for him to go one time with law enforcement to pick up his stuff, and no victim contact until further order of the court, okay? All right, Romero Pierre,
It's a medical reset, Judge.
medical reset. And then on Kevin Myrick,
Mr. Myrick is here present, Judge. He informs us he has private counsel. I believe Mr. Reedy tried. Oh, there's
he's here.
Mr. Myrick, your attorney, come on up.
And first off, congratulations.
Thank you very much. All right, so good morning, Mr. Myrick.
May I ask, Your Honor, do you have 2 probable cause affidavits?
Double check on this one again. Yes. All right, so Mr. Myrick is before the court on charge number 1 is grand theft of a firearm. Count 2 is possession of weapon or ammo by a convicted felon. And charge number 3 is battery, domestic violence.
If I may address the battery first, Your Honor.
Sure.
I do believe that there's probable cause for it. They write in the police report that their boyfriend and girlfriend, they've been living together for several years, and that he allegedly slapped her with an open hand, causing a swelling of the eye and a laceration to her lip. I believe that's probable cause for misdemeanor domestic battery. I ask the court to set a bond of $1,000. In regard to the second warrant that you have before you, there's no probable cause for any of these charges. And it's for possession of a firearm by a convicted felon and for grand theft of a firearm. If you read that very short probable cause affidavit, allegedly what happened what happened with the boyfriend and the girlfriend is what happened at 4 o'clock or 4:30 in the morning. She left the residence, and then the police came back over to the residence at about 3:15 in the afternoon. She invited them, and then they searched the home based on her permission, and they found firearms. There's nothing found constructively or on actual possession of the defendant. The defendant doesn't say if he was Mirandized, but he denied the allegations of the firearms. The wording of the police, and you have to go by the 4 corners of the document. The victim allowed access to deputies to search the home, at which time both firearms were located in the same room the defendant was originally in. What does that mean? I haven't the slightest idea. There's nothing in there saying tying or connecting the defendant to the firearms. If he was in a room, what room was it? Was it the living room, the dining room? It doesn't say what it is, and you have to go by the 4 corners of this document. Because of that, there is no probable cause. If you look at the elements for both of those charges, the elements are not met for probable cause. And I ask you to ROR him on the 2 charges and put a $1,000 bond on the domestic.
Okay, all right. Yes,
Your Honor, I would concede no PC on the grand theft firearm. It doesn't mention when it was stolen. Possession of weapon or ammunition by convicted felon for probable cause purposes, there is probable cause, Your Honor. This is his residence. He has dominion and control over what is in his residence. There is constructive possession for the firearm, Your Honor.
And I'd argue to the court that the boyfriend and girlfriend just got in an argument, and she left the house, and he left the house, and then she's inviting the police back to come in and search the home for what purpose? There's nothing tying the gun to him. It could be her gun, okay, that he doesn't even know about. There's nothing in there. You have to have knowledge, okay? And you have to have some form of knowledge as a convicted felon that you cannot have a firearm or cartridges or bullets or anything of that nature. If you look at the elements for possession of a firearm by a convicted felon, the state is lacking in the facts in the four corners of this document. Because of that, I ask the court to ROR on it.
all right. I do find probable cause as to count 3 and no PC on 1 and 2.
And the state would ask for 24 hours to perfect then.
I ask that he still be ROR'd on counts 1 and 5.
The state is entitled to the 24 hours, so I'll give him that without an ROR.
But I know that's a form of punishment, though. He has to sit in jail for another 24 hours. I'd ask that you ROR him, and then they can perfect if they want.
It's not a form of punishment, and it is what the law does allow.
Okay.
All right?
I took a shot.
Okay. Two and no, 1 and 2 is no PC at this time, and the state has 24 hours to perfect. And on count 3, I will impose a $1,000 bond.
You know, I'm sorry, Your Honor, I was talking on 1, 2, and 3. Can you
1
say-
and 2, no PC, and the state has 24 hours to perfect, and 3 is $1,000.
But you do, I don't know if you're aware, I just spoke with the public defender to confirm that I am correct. You do have the right to still ROR him and still let them perfect. You have the right to set a bond on these 2 charges.
I can, I don't have to.
No.
Okay,
I
all
wanted to
right,
make-
so. All right, Kyle Roof.
His name is Kevin Myrick, M-Y-R-I-C-K, 11-1906-67.
The roof is approaching, Judge.
I didn't know anything about what the firearms were stolen and how they were able to link the gun with them. If you can try courtroom for evidence, it has
Mr. Roof is approaching, Judge. Come on up, Mr. Roof.
All right, Mr. Roof, you're before the court for a traffic capias. It's on a driving while license suspended charge. The court does find probable cause. What does Mr. Roof wish to do?
Judge, it's me, Mr. Roof, earlier today. He wished for me to ask the court if the court would consider resolving this matter today.
All right, does the state have an offer for Mr. Roof?
One moment, Judge. The offers adjudication court costs.
Okay.
He wishes to accept the state's offer, Judge.
All right, Mr. Roof, if you wish to resolve your case, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. And Mr. Roof, do you understand everything that's going on here today?
Yeah.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
Do you need more time to speak to me? No?
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
No.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Roof? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and court costs. Good luck, sir. John Polk.
Paul, come on up, please. He's approaching, Judge, here at Maine.
All right, Mr. Polk is before the court on trespassing, one count, trespassing, and the court finds probable cause. What does Mr. Polk wish to do?
Judge, in speaking to Mr. Polk earlier today, he wishes to resolve this matter.
All right. This is a state charge?
Yes, Your Honor, the offer be time served, no return.
All right, so, Mr. Polk, do you wish to resolve your case today?
Yes, ma'am.
All right, you'll be sentenced to adjudication and time served and no return to that location. Do you understand that?
Yes, ma'am, I do.
All right, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Polk, do you understand everything that's going on here today?
Yes, ma'am, I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
None.
And sir, do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am, I do understand.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am, I understand.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck.
Thank you. Good luck, sir. Thank you.
Brian Watkins.
Mr. Watkins, come on up, please. Judge, he's approaching. He's here at me.
Okay.
How long you live in South Florida? You live alone, find your
All
friend?
right, Mr. Watkins is before the court for one count of criminal mischief.
What's the name of the company you work for?
The court finds probable cause. And does anyone wish to be heard as to bond?
Your Honor, based on the specific allegations in this case and his pending matter, I'm going to be requesting a bond increase to $500. Mr. Watkins is out right now on bond for battery, 3 counts of trespass, and 2 counts of theft. It's alleged that he was stealing at a Publix, and when he was confronted by a manager, he struck the manager.
Okay.
Judge, Mr. Watkins is going to be asking for the court to consider releasing him ROR to pretrial release. My understanding is right now, things are going better for him. He just right now got a job at working at the Shell gas station, washing vehicles, car detail. He's living in Hollywood in an apartment with a roommate. My understanding, Judge, in the case that he's currently out on, he's with the public defender's office. My understanding is, I believe the incident happened at Publix. Right now, his attorney is getting the video, which would exonerate him. So they're in the process of discovery. So, Judge, I'm asking for Mr. Watkins to be considered released under supervision with pretrial release, Judge.
All right. These allegations are that Mr. Watkins approached the victim asking for some type of help, and which was denied, asking for a cigarette. And when that was denied, he left the area and returned and poured a box of Domino sugar in the victim's gas tank, resulting in approximately $500 of damage. At this time, I am going to impose a $2,500 bond and no victim contact until further order of the court. Okay, Jerry McCall.
Mr. McCall is approaching, Judge.
All right, Mr. McCall, you're before the court on a misdemeanor capious matter. It's on a possession of cannabis 20 grams or less. It looks like you did not show up for arraignment on June 5th, and so that capious was issued. What does Mr. McCall wish to do?
Judge, Mr. McCall wishes to resolve this matter. I believe he surrendered himself, but he wishes to resolve, so hopefully the state wouldn't have an objection as far as offering a withhold to court costs.
Okay.
Your Honor, the state's offer be withhold court.
All right, so, Mr. McCall, that's the offer is what you were looking for, so I assume you wish to resolve your case?
Yes, ma'am.
All right, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes, sir.
Okay,
Yes, ma'am.
you can put your hand down. And Mr. McCall, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
I had enough.
I'm sorry?
I'm all right, all right. I
Okay.
had talked to him already.
Okay. And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Mm-hmm.
Have you
I
ever
understand.
been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I understand.
What plea do you wish to enter, Mr. McCall?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentences withhold adjudication and court costs. Good luck, sir.
Good luck, sir.
Walter Delia.
He's approaching, Judge. He's here at Maine.
All right, Mr. Delia, you are before the court for one count of trespassing, and the court finds probable cause.
Judge, and speaking, Mr. Delia, he wishes to resolve this matter.
I'm unable to make an offer at this time, Your Honor. It appears on its face this is private residence, and I really don't have enough information. Also, looks like he was just arrested about 10 days ago for resisting without violence at the same location.
Did you say at the same location?
Yes, ma'am.
All right. So at this time, I am going to leave the bond in place for $100. Good luck, sir. Vito Maldero.
He's approaching, Judge, Mr. Maldero.
All right, Mr. Maldero, you're before the court. Charge 1 is DUI, alcohol or drugs. Number 2 is DUI with damage to property or person of another. 3 is DUI with a breath level greater than .15. And 4 is leaving the scene of a crash involving damage to property. The court does find probable cause. And does the parties wish to be heard as to the bonds?
At this time, no, Judge. He gave me the phone number of his girlfriend. I intend on calling her after court.
Okay. All right, so Mr. Maldero has a total of $2,500 bond. 500 on 1 and 1,000 on 2 and 3, okay? Jerry Adams.
Mr. Adams is here present at Maine. Mr. Adams, come on up, sir. Mr. Adams is approaching, Judge, and he declined the services of public defender. You want me to talk to him, sir? Come on.
Good morning, Mr. Adams. Are you hiring private counsel?
No.
Okay. Well, you're before the court today for 1 count of petty theft. Count 2 is touch or strike battery. And count 3 is committing theft and resisting recovery of property. Okay? Now, the court does find probable cause. Does the state wish to be heard?
No, Judge.
Could I pre-release, Your Honor?
Do you have an address, sir?
Do I have what?
Do you have an address? Do you live somewhere?
Yes, 1850 Northeast 26th Street. It's an ALF unit,
Okay.
Winter Place.
All right, I'll release Mr. Adams to, pre-trial.
Your Honor, it just asks for an order of no return to this 7-Eleven.
All right, can someone please give Mr. Adams the, information for the pre-trial supervision? Thank you. So, Mr. Adams, once you're released, you have to go to that pre-trial office. Did you hear?
Okay.
All right, and
Yeah.
if you don't go to that office, a warrant will be issued for your arrest. Do you understand that?
Yes, sir.
Also, you are not allowed to go back to the 7-Eleven where you were arrested. Do you understand that?
Yes, I do, I won't.
You cannot go back there, okay?
Okay,
All right, so take that information with you and report to pretrial.
all right, thank you, Your Honor.
All right, good luck.
Your Honor, North Broward has a client that like called out of turn, very much toward the end of the court's docket on page 32, Mr. Timothy Cresswell.
Yeah. All right, Mr. Cresswell.
Yes, ma'am.
Mr. Cresswell, you're before the court for one count of petty theft, and count 2 is touch or strike battery, and the court finds probable cause.
Good morning, Your Honor. Nancy Mappson, pretrial services. Mr. Cresswell is currently out on pretrial on case number 1801346 CF 10A for burglary, conveyance, and occupying a battery. Requesting that his pretrial is revoked.
When was he placed on pretrial?
It's like late January of this year.
Okay. And those, let me see that. Those charges were what? Burglary and?
Burglary, conveyance, and occupying a battery.
All right. Why is Mr. Cresswell in a wheelchair?
He got beat up, Judge. He's also got a host of medical issues.
Okay.
It reads, yeah, he was being held down by the clerk after he punched the clerk in the face.
Okay. All right. Did the state wish to be heard?
Just noting, Your Honor, the allegations in the case that he's out on is, in that instance, he's alleged to have punched a passenger of a vehicle for no reason.
For no reason.
Don't say anything about the case, Mr. Cresswell. You can talk to Mr. Sundar about that.
All right.
He doesn't have any money, Judge. I wasn't aware of the other outstanding case, but, I mean, the only way he's gonna get out is if he's on pretrial release, so that's what I have to ask for.
Okay. Well, he was on pretrial and is before the court today. I'm on a violation of the pretrial services is asking for the pretrial to be revoked. I am going to grant that at this time on count 1, on case number 1801346 CF10A. And now on count 1, I am going to impose a $2,500 bond. And on count 2, $500. And then as to the new charge, he has a $750 bond on count 1.
I just ask that the court order no return to this West Star gas station, please.
What is the name of the gas station?
West Star gas station.
And sir, you're not allowed to go back to West Star Gas Station. Do you understand that? All right, good luck, sir.
And Judge, I'm gonna be asking the court to sign a photo order on
Sure.
Mr. Cresswell.
I will.
Thank you.
Cedric Greer. It looks like he's been on loan. Is Mr. Greer still on medical loan?
One moment, Judge.
All right. And then Kenneth Moore.
Judge, he's approaching, he's here at Maine, he declined the service of public defender.
All right, Mr. Moore, do you have private counsel, sir?
No.
Okay. All right, you're before the court this morning on uttering a false instrument is one, and charge two is grand theft. And the court finds probable cause. So, Mr. Moore, you have $1,000 bond on each count, okay? All right, good luck, sir. Luis Herrera,
He's approaching, Judge, here at Maine.
all right, Mr. Herrera, you're before the court on charge one is possession of heroin, two is possession of drug paraphernalia, three misdemeanor capias, 4 and 5 are felony capiases. Those are no bond holds and not for magistrate. You do have court tomorrow before your division judge, and the court finds probable causes to the other counts. And your bond on count one is $1,000. There was a $50 bond on the misdemeanor capias. Okay? Good luck, sir. Zagori Days.
Days, come on up, please. He's approaching, Judge.
All right. Mr. Days is before the court, fleeing and eluding law enforcement. 2 is fleeing and attempting to elude law enforcement. 3, resisting officer without violence. 4, possession of cocaine. 5 and 6, felony violation of community control. Those have no bond holds, and you do have court tomorrow before your division judge. The court finds probable cause, and the standard bonds that are in place will remain. Okay? Landon Dawkins.
Mr. Dawkins is here, present, Judge at Maine, he's approaching.
All right, more. Mr. Dawkins is before the court, aggravated stalking, and, the court finds probable cause.
Judge, my understanding is Mr. Dawkins is basically serving time, federal time. I believe he's been in custody for over a year in Coleman County, which I just found out was somewhere in Central Florida. He's just looking forward to going in front of Judge Shear. Our only question is, does the clerk have a date as far as when he's going to be seeing Judge Shear?
Oh. Do we have a, do we know? Do we have a, I don't see a date, no.
Your Honor,
Yes.
I'm going to be requesting a $25,000 bond, no victim contact, and pretrial release of the GPS monitor. I understand he has a federal hold, but I don't know if this case is going to still be pending by the time his federal sentence is up. He's in federal prison for conspiracy to commit armed robbery under the Hobbs Act. There's allegations in this case where he threatened to come to the victim's place of work, shoot her with the firearm, threatened her family. There are voicemails that were left that were recorded, reviewed by detectives, and that were identified, his voice is identified by the victim with 100% certainty. So I believe in an abundance of caution, this bond in these conditions would be appropriate for the safety of the victim.
Judge, my understanding, I believe the date of incident happened in March of last year. He's been in custody now since September of last year. Right now, from what he advised me, he has basically no financial resources. So I'm asking you to take that into consideration in determining reasonable release conditions.
All right, I'm going to impose $10,000 bond, no victim contact. That's also going to include a level 2 GPS if Mr. Dawkins posts his bond, okay? All right, Benjamin Bloom.
Mr. Bloom is here, President Maine. Come on up, Mr. Bloom.
Mr. Bloom is before the court on burglary, and charge number 1 is burglary, and number 2 is petty theft. And the court finds probable cause.
Your Honor, Mr. Bloom is currently on pretrial for case number 190077750 CF10A, possession of cocaine and possession of drug paraphernalia. He was placed on pretrial June 21st of this year. We requested his pretrial is revoked.
All right. All right, I don't know if Mr. Romero, if you heard that he's been on pretrial.
Oh, he is? Okay. What's the case?
June 21st, he was placed on pretrial on case number 19-007-750 CF10A, possession of cocaine and possession of drug paraphernalia. And pretrial is asking that his pretrial be revoked.
Judge, has that case been filed?
He was only
I
out for
doubt
about
it.
4
It's
or
the
5 days.
21st, June 21st of this month.
So it's not filed. One moment, Judge. Judge, hold on. Judge, I'm asking at this time of the court not to take action on that case. However, if the court is inclined to take action, my understanding, speaking of Mr. Bloom, he's works at a labor pool. As you know, he gets paid daily anywhere from $60 to $80. The only person that can help with his monetary bond is his mother, who's retired on Social Security. Now, he did give me the number of his mom, but he doesn't even know if she'll be able to help him out. My understanding, speaking of Mr. Bloom, he is homeless. He doesn't reside with his mother. He's 39 years old, been here his whole entire life. And Judge, my understanding is on the case that he's currently out, I believe, from what Mr. Bloom advised me, it may be a residue case. So if the court's inclined to take action on that case, I'd ask the court to impose a minimal bond reflective of a residue offense. And on this burglary, which is here before you, I'm asking for a $2,500 bond on his behalf.
Not residue. But also, Your Honor, I mean, it speaks for itself. Within just days of getting out, he's breaking into his family's home. He happened to be confronted by the victim's stepdaughter, or who knows what would have happened, and that's, at that point, is when he fled the residence. He first claimed that he never entered the home until he was confronted with surveillance video of him inside the home. You know, he was given a chance at a second look last Friday, and went 3 days. So I have concerns about the safety of the community if he's just to be released out on the street again.
All right, based on what I've heard this morning as to case number 19-007-750 CF10A, I am going to grant pretrial's request, revoke Mr. Bloom's bond, will be held no bond on this case. And as to the new arrest, I am going to impose a $2,500 bond on count 1. No return, no to this location, no victim contact.
Nancy,
Okay?
Nancy.
Anthony Hill.
He's approaching, Judge.
All right, Mr. Hill is before the court for possession of drug paraphernalia, count 1, and then counts 2 and 3 are felony capious charges, both with no bond holds and are not for magistrate. And Mr. Hill does have court tomorrow before his division judge. The court finds probable cause. The bond on count 1 is $100. John Schrock.
Good luck, sir. Mr. Schrock is here present, Judge at Maine, approaching.
All right, Mr. Schrock, you're before the court this morning. Charge 1, DUI with damage to property or person of another. 2 is DUI, alcohol or drugs. And then 3 is improper backing. That's not for magistrate. The court does find probable cause, since the parties wish to be heard.
Your Honor, State is going to be requesting a $10,000 bond on count 2, pretrial release with a TAD monitor, no alcohol or intoxicants, random testing, and no driving. Mr. Schrock's previous convictions, he had a 2014 DUI. There was also property damage in that case and enhanced breath. In that case, his breath results were .284, .296. He also had a DUI in 2003 where his breath results were above a .2. And then obviously in this matter, this involved a crash. And middle of the day.
Okay.
Judge, the $1,000 bond, which the state is suggesting, is out of Mr. Schrock's financial reach. We were going to ask the court to consider a $5,000 bond on count 2 on his behalf. Now, he's 55 years old. He's been here in our community since 2002. He is working. He just got a job about 3 months ago as a caretaker at Victoria Villa. My understanding is he lives in Wilton Manors with his partner. He's been residing there for 3 years. The monthly rent is, his share is about $750 per month. He's going to be contacting his partner to help post his monetary bond. But from what Mr. Schrock advised me, he's retired and on Social Security. He believes if the court were inclined to set like a $5,000 bond on count 2, along with the $1,000, that's $6,000, he believes his partner can come up with that with using the services of bondsman. Also, we're going to ask the court to sign an order so he can have access to his phone to get the phone number so he can contact his friend to help post his bond, Judge.
All right, count 1 is $1,000, count 2, $5,000. That's also going to include a TAD monitor on pretrial, no alcohol or intoxicants. Okay. And I will sign that order. James Capozzi.
Mr. Capozzi is approaching, Judge. Mr. Capozzi is here,
Yes.
Main Judge?
Mr. Capozzi is before the court on a criminal mischief charge. The court finds probable cause. And does the parties wish to be heard?
No, Judge, he gave me the phone number of his father. I intend on contacting him after court.
Just would ask for an order of no return to this business.
All right, the court finds probable cause. The bond is $500 and no return to this location. Do you understand that, sir?
Yes, ma'am.
Just so, Your Honor, it's for his awareness, a Chevron gas station on 2099 South State Road 7 in Fort Lauderdale.
Okay.
Thank you. Okay, I'll contact James as soon as he gets that. No problem, sure.
Arturo Montilla Paz,
Bonded, Judge?
bonded. Find probable cause. And then Jimmy Lee Walker.
He's here present, Judge.
All right, Mr. Walker, you are before the court for charge 1, petty theft. 2, driving while license suspended. 3, no proof of insurance. The court finds probable cause. Anyone wish to be heard?
Judge, we're just going to ask for a property order so he can go to his property here in custody and try and self-bond.
All right, I'll sign that. $750 is his bond.
Thank you, Judge.
Jonathan Owens.
Joe, come on up, please.
Okay, Mr. Owens, you're before the court this morning for.
How you doing? Good morning, my brother.
For charge 1, possession of MDMA, and number 2 is possession of cannabis, 20 grams or less. The court does find probable cause, and I'll hear from the parties. Pretrial is also standing.
He's currently out on pretrial for case number 1900524 and 10A for domestic battery. Requesting his pretrial is revoked. He was placed on pretrial May 18th of this year.
Okay,
Judge, about Broward College,
Okay.
it's on the left side of the street. Broward College, so some type of burger joint.
Judge, I'm asking at this time, and I know you've already been informed that he's out on pretrial, but right now in speaking with Mr. Owens, things are going well for him from what he advised me.
Please,
He's
man.
going to school.
He's had a bad day.
Shh, don't, let me do the talking for you. He's going to school, Judge. He goes to Florida Career College. He goes Monday through Friday from 9 a.m. to 1 p.m. Also, he did advise me he just got a job. It's at a burger location. He was giving me the address. It's locally, I believe, somewhere around Broward Boulevard.
No, it's off of Banks Road.
It's here in Broward County,
It's in
Judge.
Broward County. It's closer to Broward College.
My understanding, Judge, he lives in Pompano Beach. Right now, he's helping his grandmother out. She's elderly, and what Mr. Owens did advise me is basically his grandmother counts on him for help. So, Judge, he's asking at this time to take all that into consideration, determining reasonable release conditions for himself.
Please.
do we have any information as to, who the alleged victim is on this touch or strike battery? It says domestic.
Yes, one moment, Judge. Is this, Nancy, is he on pretrial with a GPS open schedule? Wait, who does he take care of, Hector?
His grandmother.
Oh, because his mother is the victim of the domestic violence battery, where it says that he struck her on the left side of her face with a closed fist and kicked her in her left leg.
And Judge, he advised me the victim on the case that he's out on is his mother, and he's been abiding by the court order as far as having no contact with her. He's abiding by that order, Judge.
He's also was released from state prison July 4th of last year from four separate burglaries of structures out of Broward, unauthorized possession or use of a driver's license. He was sentenced to 18 months in state prison. He's had supervision violations. He's been convicted of robbery, strong-arm robbery in the past.
All right, so on case number 19-005-241 MM10A, I am going to revoke Grand Pretrial's request to revoke his bond, and I'm going to impose a $1,500 bond on that case. And then as to the new charge, the possession of MDMA, he'll have, I'll leave the bond at $1,000. Okay? Jason Gillis.
Mr. Gillis is here present, Judge.
All right, Mr. Gillis is before the court on a petty theft charge. The court finds probable cause.
Yes, Judge, we're going to be asking the court to consider releasing him on pretrial release. I understand he's not working, he's on disability, he gets $666 per month. Now, he's 46 years old, been here for the past 15 years. My understanding, Judge, he lives locally here in Fort Lauderdale in an apartment by himself. He is on Section 8 housing. I believe his share is around $285 per month, Judge. Right now, from what he advised me, there's no one that he can call to help post his monetary bond. He will be coming to court. So we're asking on this nonviolent offense if the court would consider releasing him on pretrial release.
He just got out of jail May 21st. That was after he violated probation on two separate cases, possession of heroin, tampering with evidence. He was sentenced to 180 days county jail. His arrest before that, on the tampering with evidence, he was out on the possession of heroin and had his bond revoked when he violated his release conditions on that case. Additional priors include 2013 felony theft, two more thefts, 2013, grand theft 2012, theft 2011, theft 2010, theft 2010, theft 2010, theft 06.
All right, Mr. Gillis will post his bond, $750. Taiwan Donnell. All right, Mr. Donnell is before the court.
Judge,
Yes,
I apologize. I need about like 2 minutes to speak to Mr. Donnell.
Okay.
I apologize.
Okay.
Thank you.
Is there anyone, North Broward, that still needs to be addressed?
We have the last guy on the docket, Your Honor, which is Lee Broderick, but he's in downtown courtroom 7900.
All right, so Mr. Lee's in court.
And Your Honor,
Yes.
it's really up to Mr. Reedy. This really is, it's a lateral change of charge. Bond was originally set by Judge McCarthy at $3,500.
Okay.
I mean, he's being arraigned on this charge today, so he's gonna be aware of the offense. I don't necessarily see a reason to have him brought back, but
Okay.
He's being arraigned this morning?
yes.
Yeah, there's no need to bring him back.
All right, so I'll find probable cause as to the change of charge, and I'll leave the standard bond in place unless something else happens in court today, I don't know.
Yeah, of course, that would
Alright.
control.
Yes, yes. All right, that's 3,500.
Thank you.
Judge, we're ready. Thank you
Okay.
very much for giving.
All right, so Mr. Donnell is before the court for burglary, unoccupied dwelling unarmed. 2 is grand theft of firearm, 3 is dealing in stolen property, and 4 is use or possession or possessing ID of another person without consent. And the court finds probable cause as to these charges.
Your Honor, I'm gonna be requesting a $20,000 bond. GPS, no return, no contact on Mr. Donnell. I'm very concerned since, obviously this involves someone's home, but also Mr. Donnell's currently out on a $5,000 bond, out of Dade County for robbery by, let's see what the charge, robbery by sudden snatching. And that's just from, May 29th of this year. He's actually scheduled for arraignment this Friday before his judge in Dade County on that offense.
Okay.
Judge, and Mr. Donnell, I don't think his family or friends are going to be able to come up with the $20,000. Now, he just started a fantastic job at the Port of Miami. He's 23 years old, been here his whole entire life. He lives in Miami with his godmother, Judge, and that's the person who just gave me the phone number, and I intend on calling her after court. My understanding, Judge, is she drives for a Metro bus, so he's totally dependent on her as far as her financial situation in order to post her monetary bond. And Judge, I'm asking for the court to consider on count 1 a $3,500 bond. So that's what the defense is requesting for at this time, Judge.
All right, based on the allegations in this affidavit, Mr. Donnell was found with over 50 debit or credit cards. and also with a handgun, and then a stolen vehicle. The firearm was, it was stolen in a vehicle robbery in Miami-Dade. And with a pending charge in Miami at this time also. I am going to impose a $10,000 bond on count one. If Mr. Donnell is able to post his bond, he'll be on a level 2 GPS. No return to this location and no contact with the alleged victims in this case. Okay?
Judge, what was the monetary bound on
10.
count one?
10,000, and the other standard bonds are me. Trayvon Jones,
Mr. Jones, come on up.
all right, Mr. Jones is before the court, operating without a valid driver's license. Count 2 is burglary, unoccupied dwelling unarmed. Count 3 is grand theft of firearm. 4, 5, and 6 are out of county felony holds. Those are no bond holds and not for magistrate. And those holds are out of Miami-Dade County. The court finds probable cause.
Your Honor, I know you set his co-defendant's bonds at $10,000. I'm still going to be requesting, again, a $20,000 bond and the same release conditions, noting his pending cases involve a carjacking with a firearm or deadly weapon, credit card theft, and grand theft auto.
Okay.
And Judge, as you can see, those are already addressed in 4, 5, 6 as reflected with the no bond hold. Judge, he's 19 years old. Right now, he lives in North Miami with his fiance. His fiance, from what he advised me, is working. She is a caretaker. They rent. They do not own. I believe the rent is $1,400 per month. Judge, he just started working. We're going to be requesting a $3,500 bond on his behalf on count 2, Judge.
All right, so on count 2, I'm imposing a $10,000 bond. The other standard bonds on 1 and 3 will remain. He has no bond holds on 4, 5, and 6. That's also going to include a level 2 GPS, no return, and no contact. Okay. And then Patrick Vermillion. Looks like this was a medical reset from yesterday.
Mr. Vermillion is here present, Judge, in Maine.
All right, Mr. Vermillion, you're before the court. Count 1 is driving while license suspended. And then count 2 is a felony violation of probation out of Bay County with a no bond hold. You do have a $750 bond on count 1, and I'll leave that in place. The court finds probable cause. Okay? All right. I believe that brings us to the end of our docket. Thank you, everyone. And I'll see you this afternoon.